We are now in the heart of London, Regent Street, not far from Oxford Circus. Behind me is Westminster University, which we will visit. I will take you to the heart of sociology of law by inviting you to listen to a discussion with Reza Banakar, who is professor here at the university. Reza Banakar was actually one of my first doctorates back in the early 1990s in Sweden when I'd become professor in sociology of law there. Reza had his dissertation 1994 on a thesis about the dilemma of law, conflict management in a multicultural society. A couple of years later, 1997, he moved to Oxford, where he enrolled the Center for Socio-Legal Studies in Oxford. 2002, Reza moved here to London and Westminster University. He has recently become a professor in socio-legal studies here. Reza has had an interest in socio-legal theory and method, and have, together with Max Treves, co-edited books about two books about these things. His latest contribution is about the rights discourse, rights and justice. You're welcome to join me to the discussion.
As you know, I've been interested in the development of sociology of law, particularly the distinction between the empirical and the theoretical parts. And I did write a paper some years ago. It's almost 15 years now.
Is it?
Yes, in Rättfärd.
No, I remember, and I would recall that because you used the metaphor stepchild.
Yes.
If that's the paper you refer to?
That's right, yes. And I think going back 15 years, I would say that I expected sociology of law to develop into a discipline. Then my take on sociology of law was basically a sociologist's take. I came at the discipline, looked at the discipline from a sociological standpoint.
At that time?
At that time, and I felt that it could gain quite a lot by developing a more coherent theoretical basis for its research. Now, being at a law faculty, I slightly look at it from a different angle. And it's not only that, of course. I don't think that sociology of law needs to become a coherent discipline. I don't even think that it can become a coherent discipline. Some people like Roger Cottrell argue that its strength, in fact, lies in the fact that it is not a discipline. It can attract people who are, for example, in law or other disciplines to come and do interdisciplinary research. And that is why it should have very flexible boundaries, provide a home, a broad church for people from other disciplines. But of course it is very important to those of us who have invested so much time and energy in it to see a theoretical development, to see that we are not doing exactly the same thing as was done, say, 50, 60 years ago by people like Aubert, even though they did fantastic work. So I see it as a field, as an interdisciplinary.
What would be the difference, you mean, with the approach from Aubert?
I think the approach today is that we are working with the context of our research is different. So, for example, we can't forget that globalization is an important part of anything that we do. I don't really think that there is any topic within legal research which could forget the interaction between different jurisdictions, between different legal cultures, between different people in different parts of the world. This is one of the differences. The other thing is, of course, has to do with the fact that since Oba did his study of housemates, fantastic study. I mean, it remains a classic. There is no doubt about it. Since he did his study, a lot has happened. We have learned quite a lot about how to do empirical work, the relationship between law and, again, social context in which it exists. And these need to be brought to bear on the research that we do today.
By using this expression, stepchild, would you imply that neither the father or the mother is really interested
Yes.
in the child?
Yes.
No one really wants to support this.
Again, you could do that. You could come up with arguments like that, that both sociology and law are not particularly interested in sociology of law. But I do hesitate now. I'm talking primarily in the context of the academic research in Britain. And I think it is relevant. It can be extended to, for example, Sweden. Policy research is very important. It remains very important. And subsequently, sociology of law becomes important because it has so much to offer in respect to policy research.
You write about what you call legal instrumentalism.
Yes.
In relation to this, I guess, that law or sociology of law can provide a lot of, let's say, usable knowledge for the present, at least the welfare state society, how to, let's say, guide the work within welfare state agencies, etc. And you also say that, I think you agree, that sociology of law after the Second World War emerge or grow as a kind of response to this expansion of the state and using law. And how I would like you to comment, because it's sociology of law ought to be, let's say, growing and be much more important, even within legal studies, for instance. But still, it has been pushed aside by the lawyers to a large extent.
Yes, I do slightly differentiate between sociology of law as we know it in Lund. Okay. This is the proper sociology of law.
That's the advantage right. You have. You can compare UK and Sweden.
I do slightly distinguish between the sociology of law which we had in Lund or in Oslo or Bielefeld, places like that, and socio-legal research. Socio-legal research is much more policy oriented.
Okay.
Is much more engaged with issues of regulation. Because it has provided data for policymakers. And policymakers have no time for reading theory. They don't want to read theory. It confuses them. They just want hard data. So in that sense, socio-legal research is much closely linked to policy research as we knew it. And some of our colleagues, even at Lund University, within the sociology of law, did have policy research programs for many years. And if you remember, they were not particularly theoretical. The work that they did was not. Now, what has happened more recently? Again, thinking more in terms of interdisciplinary research, and then sociology of law is part of it. Then we've also got law and politics, we've got law and literature, we've got law and economy, and so on. We see that it has come into legal, within the traditional areas of legal research more forcefully. One area, it's not, admittedly, it's not a traditional area, but has been deeply influenced. And now I think it almost overlaps with sociology of law, is of course comparative law. Anybody interested in European law, studies of European law, must have an idea about comparative law.
Yeah.
You can't really do without it now. And comparative law has also nestan exploded over the last 10 years because it has shown its relevance to harmonization and unification of laws in Europe and elsewhere.
Yeah. Reza, you have recently written an article about from industrialization to globalization. And globalization is a topic you have dealt with in different respects. You bring up different themes in that article, and some of them we have already touched upon. You start out that article by talking about the openness of sociology. Yes. Is that something which also spill over, so to say, to sociology of law?
Yes, I think so. I mean, that is the part of the strength of sociology of law comes from that openness. Sociology is a discipline, but it's has always stayed open on the one hand to scientific branches, searching for natural laws and causal analysis. At the same time, it's been open to art and concern about the human condition. So humanities, generally art and sciences have played a role in the development of sociology. And I think this is the most important thing that sociology of law takes from sociology. It's this openness and flexibility, and it has been very sociologists borrow from everyone, from lawyers going back. Of course, law played a very important role in the development of sociology. From psychologists, from economists, from biologists, from anyone who's got anything interesting to offer, they will take it and develop it as part of their own epistemology.
Would you say that sociology of law is more or less closely related to the growth of the industrial society and perhaps the welfare state, where the law was used as a tool for social engineering?
Yes, I think it is one of the main sources. It is one of the main sources.
And even driving force for developing a sociology of law?
I think so. I think, I mean, going back to Hydén and in Europe and Roscoe Pound in North America, both of them were interested in social reform, and that was why they decided to use social sciences, either to develop law or to use law more effectively. So partly to develop law internally. I think people like Ehrlich were more interested in the internal transformation of law, and also Petrozhitsky and other lawyers. I mean, they were all lawyers. They used social sciences because they wanted to transform it internally. But others, and Roscoe Pound is perhaps a representative of that group, were more interested in a more effective application of law. And it all fits nicely into the development of welfare society. I mean, my reading of Luhmann has been that he managed to show the interdependence of the internal and external. However, some people read Luhmann differently and say that he really believes that there is something which is completely external to the law. But the boundaries of law are being constantly defined and redefined in relation to the environment. So there is the environment is very much part of everything that law does internally. So I think that is a very sophisticated, elegant way of bringing these two together that Luhmann has done. If we depart from Luhmann's system theory, because Luhmann's systems theory is a very coherent, very logically, closely and carefully constructed system, and then obviously the only intervention is through structural coupling.
Yeah.
That is the only. There is no direct. If direct interventions happen, then it is corruption of the systems. This is.
Yeah.
There are some people who have developed this. They
Okay.
actually talk about, for example, corruption within the legal system as that intervention. This can happen, but it is not good. I'm not quite sure that, although I find Luhmann quite helpful when it comes to helping us to explain things, I haven't found him very helpful to start research with.
No.
One should be very careful when it comes to that, because after all, he did not develop his theory empirically.
No.
It is a theoretical, in a very in a good old German tradition of theorizing.
Exactly.
He started with theory and he ended with theory.
Yeah, well, that's interesting.
And it is also a very Western, but he says that. He's very clear on that. It is about Western legal systems.
Another classical sociology of law problem you touch upon in your article is what you call the gap problem. Yes. And the gap problem might be a broader way of approach compared to the law in action, law in books distinction. How important would you say that this gap problem is for sociology of law?
I think it is an integral part of the sociology of law. It has been from the outset, and it will remain. Yeah. It is a very important way of collecting data. I was a bit critical of the gap before, and the reason was that I felt that it did not generate theoretical breakthroughs, and this is a fact, because the theoretical contribution is this: that there is a discrepancy between the law in the books and law in action. Well, we know that. Yeah. Now, why should we go and apply it 1,000 times to different situations? Well, one reason is that we do collect very valuable data through these studies, which could be used by other people who are more interested in theoretical development of the subject. So the gap remains, and it has developed. I also mentioned that we find a new type of discussion and analysis of the gap within comparative law in relationship to transplants. Borrowing legal institutions from one jurisdiction and planting them in another jurisdiction. And of course we've got fantastic studies which show what happens once you do that. And of course the best example is, at least for me, is the Ombudsman, which is a Swedish construct. And we see how the institution of Ombudsman been introduced into different jurisdictions and what has happened with the institution, how it has developed. Again, we see how the context, the legal and social context, impacts on the development of these institutions.
We talked about legal transplants and the problem, of course, related to that. I wonder how you regard European Union in that perspective. Is it possible at all to create more or less uniform legal system within Europe with their different legal cultures?
Of course, there is a debate on that. On the one hand, we've got comparative lawyers who systematically work. There are very large projects in different parts of Europe run by comparative lawyers who work on the unification of the legal systems. On the other hand, we have people who argue that it is an impossibility. One of them, of course, is Pierre Legrand, one of the people who argue, and he says, well, two things exist separately. Now, two legal systems exist separately because there are certain fundamental differences between them. If you take away these fundamental differences, then you don't have two different things. You have one thing. It's a very powerful epistemological argument. So the difference is very important, and for him, the preservation of the difference is very important. But of course, we shouldn't forget that he is Canadian, and it is very much, his argument is very much rooted in the liberal ideology of multiculturalism of Canada, which has been a success, and he celebrates differences. But of course, there are many other people who also use differences, but they use it negatively. I mean, racist organizations are one of them, for example. They also are, they believe that difference is the most important thing, but they do not put it in that liberal context. Now, the question is to what extent we can, what one can or should unify the legal system, and also we should perhaps distinguish between harmonization and unification. Unification is a different project. Harmonization is much more realistic, especially since we do have different legal traditions. We have common law traditions, and then we've got within the civilian countries there are huge differences. We've got the Scandinavians and the Germans and the French and the Italians and so on. They all belong to the same family of civil law, but nonetheless there are huge differences between them. What happens to the directives when they hit the ground depends on the legal systems, and it will remain on that. So I think harmonization is a realistic aim, ultimate goal, but unification perhaps not. It's not even normatively sustainable. So there is a lot of, there is a point in those who argue against it. And again, if I for the third time refer to Roger Cottrell, he's got a really nice paper which is called Why is Being Different Bad? So what is wrong with being different? So the legal systems, I mean, there is a point in maintaining the differences between legal systems. And it is their identity, of course. So within the projects of, within the European project, I think there is a lot of space for accommodating these differences. And I don't really think that there are many people who hope to create a common law of Europe in the sense that it existed many, many years ago, I mean centuries ago. Jus commune, I mean, existed. I mean, I don't really think that there are many people who got that as an ultimate aim today.
You use in your article also a distinction between two kind of more or less paradigms within sociology of law. You're talking about a classical top-down approach and a bottom-up approach. Could you elaborate a bit on that? I think it has also a kind of historical background.
That's right. The top-down approach is when we start with the law, with the positive law, with legislation, and ask questions about how law impacts on society or social behavior. So when we start with the law, we automatically assume that law is the law. That is to say, law is the same as what the courts do, what the parliament introduces as what parliament legislates, and so on. We don't ask questions about how people perceive it. What do people perceive as law? And what sort of norms do they actually use? So we could now, to go back to Vilhelm Auber's study of housemates, I mean, that's a very good example. He starts with the law, and he asks questions about how the new legislation, the new Norwegian legislation, impacts on the behavior of housemaids and housewives. He could have done it differently. He could have started with the housemaid, going to the housemaids and housewives and asking them, how do you regulate your relationship? What sort of norms do you use? So he could have done that, and I think he would have produced a rather different study. But of course, I think he did have funding from some agencies, and the study was conducted as part of the debate on legislation. So it fed back into the Norwegian legislation because they did develop it later, some years later. And mind you, I mean, I say that I think, as I said before, I think it's one of the best studies I've ever come across. Still, I mean, after 50 years, we can learn something from it. So it was done very well, and the reason for that was that Auber and Eekhoff and others who did this study, they were very sensitive to the social context. They did have a fairly sophisticated sociological understanding of the interaction between housemaid and housewife, and what contract is, and what sort as a social relationship. So the top-down, the first one is bottom-up, when we start with the law. The second type of studies is the bottom-up studies, where we actually start by asking people about what they do, how do they organize their everyday life, and then we can see, perhaps they don't even mention law. Perhaps they don't refer to law. This is this, for example, Macaulay's study of contractual relationships showed that businessmen try to avoid law. I mean, this is not the case these days, of course. I mean, business is very much dependent on law, but this is, again, Macaulay's study is almost 50 years old. So, and where he studied it was the case. But I mean, the content of how valid his study is not really relevant. The point is that he used a different type of approach. He went and asked businessmen, trying to find out what they actually did when they needed to write a contract, or in relation to contractual relationships which existed between them. I'm more partial to the second one myself. I think it is grounded theory. It is.
In what sense do you mean?
That you can't go wrong, because if top-down studies are always dependent on a particular theory, bottom-up studies, they generate the theory as they study the reality of their research. So the chances that you go wrong when you do bottom-up studies is very small.
Do you think there is a trend in this shift from top-down to bottom-up, which is also related to the, let's say, the diminishing role of the state and the increasing role of the civil society and other movements?
That is very true. Yes, yes. I think the recent studies have moved towards emphasizing soft law, which is non-state law. And these laws, we can only make sense of them only by seeing how, for example, corporations, or it could be lawyers, generate laws outside the outside sovereign states. So that is very true. It's become much more important.
Do you think that the concept of norm could provide a kind of bridge, or the concept of norm grew in importance in relation to these movements, where you don't have a pre-shaped legal norm to stick to? I mean,
it definitely provides a very powerful approach. I think I can imagine. It depends. It really depends on the context. In some contexts, it would be very effective way of doing it. After all, these legal rules and social and connected social norms provide the basis and of this development. So I think you could do that, but again, I've got to think certain. I can give an example of where norms could not, for example, be very effective. I've done a study of anti-terrorism legislation, and of course, anti-terrorism legislation is really cannot be. You can't study anti-terrorism and security issues without putting it in a global perspective. And for example, in that sense, in that context, I think norms would not be very effective for what I wanted to do, because I wanted to look at discourses. I wanted to see how anti-terrorism legislation and also concern with security, national security, interacts with different interests.
Would you agree that in relation to information society and what we call in a research project cyber norms, yes, for instance, that the concept is relevant to capture the new behavior?
Absolutely. Yeah. Because there you're focusing at least partly on individual behavior, on how individuals they interface with other individuals through the medium of cyberspace. And I think that is, for example, that's a very good example of where norms work effectively.
We have talked about Willem Aubert a couple of times.
Yes.
And that is certainly natural for sociologists of law, having their background in Scandinavia.
Absolutely.
Of course, Willem.
Yes.
And one of his distinction in relation to conflicts, as I recall, was about interest and value.
That's right, yes.
And so the question, what we have discussed to a certain extent, is if only value form the basis for norms, or if even interests could be understood and give rise to let's say, normative standpoints and norms.
Right.
I guess that your initial objection is about interest might be more, let's say, flexible and not as stable, and therefore values might be form the base for more consistent normative behaviors, let's say.
Oh,
if you understand.
Yes. I've got no problem with conflict of interest. Laying the foundation for norms, for generating norms, obviously. I think that is clear. Okay. But that is a foundation. The interest itself is not normative.
No.
I think. I mean, this is. The truth is, I haven't really thought about it. I'm quite familiar with the interest of conflicts and conflict of values and conflict of interests. But I never thought about it. I've got to think about it. But spontaneously, or rather from top of my head, I could say that interest itself is not a norm. Is not. I mean, I think Max Weber also has various discussions on values and so on, and
he had this sexrationalitet and
that's right. I mean, these are also the other question. I think perhaps, again, as I say, I might regret saying that later, but it seems that interest is a factual, is more like related to facticitet, is factual than norm. But of course, I mean, I'm hesitating all the time because without certain values, we won't be able to identify interests. Isn't that so?
Yeah, that's
right.
Yeah, you can't make a sharp distinction.
Yes, it isn't. I mean, it is. So these are analytical distinctions, really.
Yeah.
In everyday reality, it is much.
And I think for my own sake, I mean, it's important to, as you know, to extend the concept of norms, not being only, let's say, geared towards social interaction and so on.
Yes.
That also, let's say, what I would call systemic norms, norms based on the rationality of a system, for instance.
Yes.
And therefore, I mean that there is a kind of similarity here, that norms related to the rationality of a certain interest. If you have an interest position,
yes,
you can deduce certain, I mean, normative standpoints or norms following by that. Sticking to a certain interest, certain behavior become rational. And in that sense, you could talk perhaps about norms without a sender, so to say. Norms.
Yes, I agree.
You talk about three conditions that sociology of law has to meet in the perspective of globalization. Sociology of law, as law itself, I guess, meets three challenges, or has to fulfill three conditions you're talking about. And you then mentioned, what you mentioned is the intellectual origin of sociology of law, the hybridization of legal cultures or legal systems, and the new global forms of social organization.
The first one about the Western origins of the sociology of law. I didn't say that it has to get rid of it, because it can't get rid of it.
No,
it is its foundation, but it's got to become very, it's got aware of the fact that it is Western, it is based on a Western tradition of thought. So when you go to other countries where the legal system is not, for example, autonomous, When you go to other countries, non-Western countries, I mean, I can give you an example. For example, Iraq, Afghanistan, or Iran, or Saudi Arabia, just to give you a few examples. If you approach their legal systems from the point of view, from a Western point of view, that could be very misleading. The law is not Western law, it is not autonomous, not that Western law is autonomous, but it is part of its values, foundational values, is autonomy. It is all the time, it is striving towards gaining greater autonomy. But in other places, law is embedded in social and cultural aspects of the society.
Hybridization.
I think it's part of globalization. It's part of, a very good example is when European law becomes the source of law for all member states. It brings them closer together. All legal systems are hybrids. All of them contain elements of other legal systems and other legal traditions and other legal families. So there is no such thing as pure common law or pure civil law or pure Sharia. They all borrow, exactly like languages. William Twining uses another concept. He talks about diffusion of legal systems. And diffusion of legal systems is not only caused by the interface of the legal systems, that two different legal systems are brought face to face and impact on each other, but also internally. For example, through migration. Round the corner from here, there are Sharia courts in operation. Sharia courts which are not recognized by common law, right? Common law refuses to recognize the decisions of Sharia courts. But the fact of the matter is that they are in operation. People actually get divorced through them and get married and divorced and resolve their disputes through them. Changing character of law and society is nothing new. Industrialization increased the speed of change, but globalization has enhanced it even more. So we live in a global society where everything changes. Before we have managed to grasp how to behave, the conditions for our behavior has changed. This is one of the issues which is developed by people like Zygmunt Bauman and in other terms by Ulrich Beck and Hydén and so on. And of course, sociology of law has to grasp this, because the conditions for regulation has changed. The effects of the structural relationships on individual behavior has changed. Some people argue that globalization has reduced that, minimized that, or constrained the effects of social structures on individual behavior. So this is the third point.
How would you relate globalization in these respects to, let's say, the information technology and the emerging information society or knowledge society or service society, whatever we will call it? What would be the relation for you?
I think it is the foundation of globalization, because globalization, if we understand it purely as an economic relationship, that is nothing new. It has always existed. It can go back to the old empires of the Greeks and Persians and the Chinese. They used to do, they were global. They built global empires 2,500 years ago. So that is nothing new. But what has happened, what makes globalization interesting, is precisely this information technology and the network which exists with it, which has enhanced relationships, but also changed the interaction between people once they are in cyberspace. And also the way they produce norms and the way they produce communities.
Yeah. In the end, in the very end of your article, you claim that sociology of law has to be able to capture the ongoing interaction, I think, you use between the solid and liquid forms of social life, and map also the emergence of new forms of law, I guess, in the end of that article.
Yes.
What do you have in mind then?
When I was the new forms of social law are laws which are produced outside the traditional sphere of state. We call them soft law or whatever, transnational laws. And the other thing that you mentioned was...
No, I mean, you talk both about new forms of law, but also new forms of social life.
Yes. Yes, I mean, the new forms of social life that we experience today, of course, much of it has to do with cyberspace, the interaction in cyberspace, which is different. But there are other things. There are communities which are very liquid, and these are not necessarily dependent on cyberspace. The banking sector is an example. For example, in London, the city, there are groups of people who are very liquid, but they are at the same time a community. Group of bankers who caused the near collapse of the global financial system. It is actually, you can go back and identify a group of young bankers working for JP Morgan. And what is interesting about them is that it was the people who created the credit derivatives. It's them. They invented it. And the reason they did that was to reduce the amount of capital they needed to have in order to lend money to investors. And what they did, there is nothing illegal about it. So there was absolutely no reason to control these people. But if you want to control them, if you want to regulate them, you see that you cannot regulate them.
Why?
For one thing, for example, here they move outside, they move somewhere else.
The liquidity.
Yes, I mean they are. It's just yes.
To escape.
So it's not even escaping. It's just a global financial system. Is outside the reach of traditional forms of regulation.
But when you talk about new forms of social life, would you include also social media, Facebook, network?
Absolutely, yes. All these are all new forms.
And probably we haven't seen the
we just
full
it just
range
started. It has just started, hasn't it? So we have to see how it develops.
Yeah.
It's positive law, isn't it?
Yeah.
It's positive law produces legality.
Yeah.
And not justice. That is the. However, once you mention law to ordinary people, or lawyers for that matter, they do claim that there is a relationship between law and justice.
Yeah.
So law without justice is not proper law. Everybody accepts that, whether lawyers or non-lawyers. Having said that, once you get down to legal positivism, the foundations of legal positivism, it tells you that all we can offer is legality. Justice becomes an ethical issue, a political matter, nothing that positive law can I mean, I must say that the legal positivism